And welcome everybody to this afternoon session. Lovely to see so many of you are interested in joining us to talk about debt recovery. This afternoon we're going to talk about the nuts and bolts of debt recovery and what we've seen over the course of the last year. But we're also going to try and put that in a little bit of context for you about some of the challenges we've seen and some of the changes we have ahead to help you in your planning. If we could have the next slide, please, Emmy. So, in terms of themes, I'm sure that many of you will have discussed themes with local bursars groups and associations, but we've noticed various themes over the last year, and we've also had an opportunity to have early sight of the Independent Schools Financial Benchmarking Survey, which was undertaken by Rhiannon Cutler and Baines Cutler. And what they have talked about is that most schools decided not to increase fees last year, but the majority propose an increase for September this year. Indeed, a significant minority have already did so in January. The very vast majority made discounts of fees over the course of the last year due to COVID. Now, we were all wrestling with quick decisions to be made in relation to how to manage the impact of COVID. And schools were required to consider how best to liaise with their parent body in relation to fees. And we saw a number of different approaches. Some immediately offered discounts, some preferred to hold fire and maintain fees. Others said, well, what we'll do is we'll see how we get on, and if we make savings, we'll pass those on to parents. The Baines Cutler report said that some 95% of schools ended up making some discount of fees, particularly in relation to summer term fees. And you would think, wouldn't you, that that would make debt recovery a little easier. In fact, that's not proved to be the case. And even where there have been discounts of fees, and sometimes significant, we've seen higher discounts for prep schools, perhaps just representing that piece that you're not able to replicate all of the education and support for the younger pupils as readily online and on a remote basis as you would for older pupils, and again greater for boarders. So most made a discount of fees, but the arguments that we then saw as a consequence of that was around parents saying that the discounts weren't fair or weren't enough, or it just changed the emphasis of the disputes that we were seeing. Most schools have also offered hardship awards or bursaries or some sort of system mechanism for supporting parents, may even be in terms of a bit more leeway than you ordinarily would before escalating credit control and debt recovery processes. And most have been really sensitive to the particular challenges of the pandemic. That's always easier when you have parents who will engage with you. So if you have a parent body who are telling you when they're having problems, they tell you what it is they're doing and what the impact that these things have on them as a family, it's much easier to plan. The ones that are much harder to deal with are those parents who say nothing and then scream unfairness at the point at which you seek to escalate matters in order to protect the school's position. So in terms of schools, those are the sort of issues that we've read about. The other thing that Baines Cutler did was undertake some research into the amount of additional COVID costs, and they found that that schools had some fixed additional COVID costs, perhaps not as significant as might have been predicted because of the benefits of the furlough scheme and other aspects. But taken as a whole, the fee discounts and COVID costs seem to amount to about 10% for the majority of schools. And that seems to fit quite neatly with the usual 10% fee surplus that schools are encouraged to carry, such that thankfully most schools have been able to weather the situation thus far. There are always, of course, financial pressures, and the longer the pandemic continues, the more difficult it will be, particularly, it seems, for the standalone prep schools. So, in terms of what we've seen, we have seen more fee disputes. They have ranged, if you like, from the usual ones, the ones that you would expect us to talk about. So, validity of notice, that the school had waived a right to pursue one parent after a separation piece, that fees in lieu of notice are an unfair term, that signatures have been disputed, and of course that the school had failed to perform its side of the bargain, such that there are arguments around breach of contract. We're still seeing those. But what we are seeing is more technical legal argument, mainly relating to the quality of services offered, but we're also seeing more related complaints. And historically, we would have a situation where the majority of the time, parents hadn't raised a complaint. Schools would look to pursue a debtor after the child had left, it being much more difficult to pursue a court process against somebody that you're still needing to maintain a relationship of trust and confidence with. And there was a very little interplay between complaints and fee debts, some, but little. This time around, it seems to have been much more interlinked. And what we've had is a number of situations where there's been that sort of lack of clarity around whether a disputed debt actually falls to be treated as a complaint first. And there are some nuances to all of that, which I would be pleased to pick up another time or to cover. I wrote an article about, and I can share that with the follow-up, relating to issues such as what your complaints procedure says, it not being something that does need to be covered by the independent school standards, what expectations are, whether the parents have got another route through the debt recovery process, and whether their argument is really about services delivered at the school when the child was there and the extent to which it is actually a fee dispute. So lots of those sort of aspects. And if we move on to the next slide, the other issues that we've seen more of are around the various issues that are spoken about on this slide. So force majeure as a start. Force majeure is a legal concept which comes into play dependent on the terms of your clause. If someone is prevented from delivering what they have bargained for, what they have contracted to do, on the basis of an external event, an event outside their control that's completely unexpected. So the first time I really saw it was about dust clouds and people not being able to get on planes to come back. a lot of people have talked about it in relation to COVID. Most of you will know about it because of the reliance on force majeure clauses by insurers in considering whether or not they will pay out when it came to schools claiming COVID-related losses from them. In our experience, not many schools sought to invoke force majeure clauses in relation to their parent contracts, not least that the view was that they could substantially deliver services, weren't prevented from doing so, they could do it remotely, and therefore it wasn't appropriate. What we have seen is some creative parents, and you'll have probably heard me say before, there are a vast proportion of the debtors that we see who are either lawyers or have done some law at some stage, and therefore will seek to invoke some of these principles. So sometimes we saw some debtors saying, well, actually, we are prevented from paying by COVID. Now that doesn't wash as a legal defence to a claim on the basis that it's not COVID that prevented them from paying. It's not sufficiently direct, but we saw a lot of arguments about it. The other thing we've seen a lot of arguments about are that the discounted fee still doesn't represent value for money, and this real misconception by parents that when they are entering into a contract with the school, that they have a right to complain or discount if they're not getting value for money. Now, of course, parents will get a lot of protection as consumers under the consumer law that we speak about quite often in these scenarios. But essentially, that is because the school enters into a contract with the parents, and that is not an individually negotiated one. And so the school is under an obligation to make it clear what that parent is getting. And if it's not clear, then the school is under, essentially the discrepancy will be determined in the consumer's favour. Provided the school is supplying the services that it contracts to do within the terms of the parent contract, and of course within the wider representations that are made, so marketing materials and comments that are made, provided it is fulfilling its contractual obligations, then the parent is required to pay regardless. And the feature around value for money shouldn't apply. Of course, what we see are parents saying, well, no, the school didn't deliver its contractual obligations. And quite often what they'll say is, well, the school couldn't do so remotely. Now, all of these things will depend on the terms of the contract that you have with your parents. The ones that we know best are obviously ours and the ISBA contract prepared by Farrers. But we see all sorts of parent contracts, and some where there are none in writing at all. Not that we would recommend that, I hasten to add. But our parent contract, for example, first of all, gives an opportunity for a school to change the mode of delivery. And secondly, it doesn't prescribe that schools will provide everything at a particular time. And therefore, there's a facility that if children are missing out on some of the contracted services, for schools to pick that up and deliver it later. But we see these sort of arguments. And the other argument, which I think is somewhat ironic and comes from a real misconception from parents, is the argument that they shouldn't be liable for summer term fees in exam years because they're not getting any tuition, without recognising that last year, more than any other, the amount of extra work that staff were doing in coming up with centre assessed grades and then going through the appeals processes that happened afterwards. But we did see a lot of that too. We did see people saying, oh, well, we'll only pay for the weeks that a child was in. All of them have legal responses, but all of them have an obligation on the school to deal with. And one of the other common issues we saw is this failure to be able to really discharge a duty of care to pupils with special educational need or disability, and to be able to do so effectively on a remote basis, depending on the child's needs. But those are the sort of issues that we saw the most of. In terms of what that then means, if we go on to the next slide, first of all, it meant that the cases were higher work, more was involved in responding to technical legal arguments and managing the process before a school wanted to actually press the button on debt recovery. But then when we did do that, real backlogs from the court, real leeway from the court, and a lot more sort of flexibility towards debtors. We saw remote hearings, which are great and very efficient, and remote mediations too. But in terms of pressing things forwards, real obstacles in terms of process servers, High Court enforcement officers, bailiffs having to write to debtors before they could go round to check whether they had a particular vulnerability, having to have COVID-safe procedures, not being able to enter residential properties, not being able to enforce any possession proceedings, those sort of aspects. So things have been like wading through treacle through the courts over the last year. And while you would hope that things will be better and getting back to normal, we are still dealing with those sort of backlogs. And as Nick will talk about in a moment, real changes which are again giving debtors more time and more flexibility. In terms of how we are seeing things in relation to those particular COVID defences that we were talking about, well, actually, we still haven't had a COVID case go to trial. So thus far, our parent contract, and we know the ISBA parent contracts have held up well. I know because of discussions that we've had through the ISC COVID group that schools generally were encouraged to think carefully about which case would be the one that they may want to take forwards. So perhaps not to take one about the younger children where the arguments are much stronger, or about boarding where the arguments are different. And essentially schools have been trying to deal with matters on an individual basis, knowing of course that if a COVID related defence were around discount and whether the school had fulfilled its contractual duties were to go against the school, that may open up the floodgates to claims from the remaining cohort. So if we move on to the next slide, I just want to talk a little then about the recommendations that we have about dealing with credit control and debt recovery, and to share those with you as a result of looking past, but also in relation to thinking about things going forwards. So the first thing is about early engagement with debtors. We've talked a lot over the years about really knowing your debtors. We've talked about whether you should do credit checks on parents before they come along. But at the very least, you need to understand a debtor's financial situation, and when things start to go wrong, to encourage a dialogue so you can try and sort those things out. I was heartened to hear Baines Cutler talking about a know your parents sort of process. And actually, they said that they thought it was really important when you're dealing with issues such as tactics around pricing, about credit control, about debt recovery, to engage not just with individuals who are having problems, but to engage with your parent cohort generally. And we're talking about it all in the context of safeguarding, aren't we? But yet another recommendation has been made about reaching out to your parents and consulting with them or surveying them about these sort of issues in order to engage and to show that you're listening. So that's one thing. The next thing is around clarifying hardship offers and bursary rules. And what we saw last year was that a number of schools, when it came to fee discounts, said, and if you can pay the full fees, we would encourage you to, and we will put any extra over the discounted fee into a hardship fund to help those who perhaps can't. Now, that was popular and had a surprising, I think, number of parents who were willing to pay the full fees and to support others in that way. But when parents are saying the school is unfair in pursuing debt recovery, being able to say that you have signposted what arrangements you have that might be able to support them, and in particular made it clear whether there are any time limits about those, how they should go about applications, whether there are any other conditions that may relate, I think is very helpful when it comes to dealing with arguments around unfairness and indeed the reputational risk that you carry with these sort of aspects. The next thing I would recommend is around thinking ahead. So everybody wants to act in the best interests of pupils, and particularly pupils who've been so severely affected by the global pandemic. And I think we all accept that transition at the end of an academic year is much less disruptive for a pupil than a transition at any other time. So I really would encourage schools to be thinking about debt recovery as early as possible. And actually, it's even not too late to do so now if you have some debt, because those sort of essentials, if you've got parents who still haven't paid, you can provide notice of non-payment. And rather than wait to do that or until the beginning of the autumn term, doing so now and encouraging them to think about transition and finding another school for their child at this stage is, I think, helpful again to deal with those sort of arguments that you might have later. You do need to ensure regulatory compliance. Debt recovery, when a parent turns around and says, yes, but the school didn't fulfill its duties in whatever way, and gets messed with complaints to regulators and other aspects, becomes very much more difficult. And in the meantime, you often have the debt continuing to accrue. So do think about that, especially where complaints are raised, and make sure that you've fulfilled your complaints handling obligations before pressing the button on the debt recovery. I do hear people saying, oh, well, they're two entirely different processes. And I think when you're dealing with consumers, it's very difficult to divide them in that way. I've put divide and conquer. Actually, it wasn't in that context that I was talking about. What I was meaning there is that if you have parents who are disputing their liability to pay fees, particularly if it's a group of parents who are unhappy about a particular issue that the school is seeking to do. Then it can be helpful, I think, to really engage on an individual level with parents and to differentiate matters relating to their particular child from the group, to be able to try and resolve cases, and slowly over time get the majority of the payment before you decide what it is you want to do about the balance and whether actually you'll take legal action in relation to those. And the last thing is, at this time, more than any other, the courts are, if not forcing you to mediate or compromise, there is a very strong expectation of it. And schools who look to say, we are going to pursue the entirety of the debt no matter what, doesn't always land well. That doesn't mean you're not contractually entitled to do so, but I think that that willingness to actually consider particular circumstances on individual debts is also important to successful debt recovery of your whole portfolio. Okay, so those were the bits that I wanted to talk to you about. Nick is going to go and talk about anticipated changes, and then we'll come back to some questions and answers after that.
Thank you, Tabitha. Hi, so I'm going to be talking to you today about some anticipated changes. So we've heard what's happened, things that have happened over the last year. I'm going to be talking about, particularly over the coming months or year, in a in a debt recovery law point of view. What do we think is going to happen? What have we seen happen? And how are these going to affect you as schools? So the first is the main change that's already happened. It's the debt respite scheme. Now, the reason we're talking about this as an anticipated change, even though it's already happened, it came into force very recently. It came into force at the start of May 2021. But obviously, with that, the extent of its impact isn't yet known. And that is going to be something that we discover and learn more about, and learn about the impact it's going to have on you all in reality over time, over the coming months and over the year, I anticipate. What is the debt respite scheme, I suppose? The debt respite scheme is designed to help individuals struggling with debt. Obviously, there has been a lot in the news, not just over the last year, but over the last 4, 5, 6 years, about the extent to which individual debt is been significantly increasing and becoming harder to manage for a number of people. And the point of this regulation is public policy is what's brought this about. It's to assist people who may be struggling to take literally, it's called the breathing space regulations for a reason, to take a breathing space and seek debt advice without incurring additional interest or being pursued by creditors. Breathing spaces are available to anyone who may be struggling with debt, someone who may be unable to pay their debts or pay a specific debt. And they're the people that may apply for a breathing space. And apply they must. They can't just award themselves a breathing space. So if you were to be contacted by an individual saying, I've decided to have a breathing space and not pay my school fees, they can't do that. They have to apply to a local authority or a debt advice company who will evaluate their position. So a debt advice company being a regulated debt advice company, regulated by the Financial Conduct Authority, be able to approve whether or not an individual on the balance of things is unable to pay their debts or a debt and is therefore in need of a breathing space. I anticipate that these are going to be used largely by frankly, insolvency practitioners, so people who are helping people decide whether they want to put an IVA in place, so an individual voluntary arrangement, which is as you'll no doubt know, an arrangement with their creditors, all of their creditors as a group, to work out perhaps an agreement on paying a proportion of a debt rather than a full amount. And I think that's realistically where we're going to see these used. What does it mean for you, though, as a creditor? If we could move on to the next slide, thank you. So I've listed the things that you will have to do if you're notified of a breathing space, or some of the things you need to do if you're notified of a breathing space. The starting point to note is that if you're notified by a local authority or an approved debt advice company that a breathing space has started, it means it probably has already started. The fact you've been notified means that it will have been escalated to the insolvency service. The insolvency service will have recorded it on their register of, they've got an electronic register of breathing spaces that will list all the people, and below that would list on the insolvency services end all the creditors of those people who need to be contacted about a particular breathing space. So the first thing you need to do is stop all enforcement action. That's if you're about to issue a claim, you have to put it on hold. If you're just at sending letters stage and you haven't even escalated it perhaps to solicitors or a debt collection agency or whatever you use, you have to put a pause on that for the time being, and you can't pursue not only the debtor but anyone who is jointly, as I've noted here, jointly and severally liable for the debt. You must also notify the court if you have started court action. You must make sure that interest, fees, penalties and charges don't accrue on a debt during a breathing space. But also you must not make contact with debtors during a breathing space. That's probably the most important of all the points, and it kind of sums up all of them, which is just stop taking action during a breathing space. In terms of the types of breathing space that individuals can apply for, there are two types, and if we could skip to the next slide, we've got the standard breathing space. A standard breathing space is available to anyone with a debt issue, either a debt or debts that they're not able to repay. It lasts for a maximum of 60 days, and it can only have, an individual can only apply for one breathing space every 12 months, one standard breathing space every 12 months. There is another type of breathing space, which is the mental health crisis breathing space. These are only available to individuals, as I've noted here, who are receiving certified mental health treatment. So I anticipate they will happen less frequently than the standard breathing space. But if you are notified of a mental health crisis breathing space, then it's important to be aware that, frankly, it could go on for an unlimited period of time. The protection will last for the entirety of that individual's treatment, plus an additional 30 days after that. What I would do if I were you, when you are notified, whether it's a standard or a mental health crisis breathing space, is to make contact with the debt advice company or the debt advisor that has notified you of the breathing space, to touch base with them in the first instance, but in particular with the mental health crisis breathing space, to ascertain whether they have any information that might help you understand how long it's going to be in place, or as it progresses, you know, as weeks turn to months, and hopefully not, but months turn to years, when it might actually come to an end. Because otherwise, you know, it's best to put yourself in the light if you can on that. The next piece of information is about qualifying debts. And a qualifying debt is, unsurprisingly, one that qualifies for protection under a breathing space or by the moratorium. So in other words, a debt that when a breathing space is in place, you're not allowed to chase. Frankly, I consider it's likely to be any debt that a school is likely to be pursuing. It essentially is all personal debts except secured credit, so things like mortgages, that type of thing. So unfortunately, school fees, fees in lieu of notice, extras, payment plans, unsecured personal debts are all things that would be protected in a breathing space. So in other words, things that you would not be able to chase whilst a breathing space was in place. What is positive, one of the things that isn't a qualifying debt is something covered by an attachment of earnings that was issued before a moratorium was in place. So if you already had an attachment of earnings order in place and you were receiving payments from, say, the employer of the debtor in question on a monthly basis before the moratorium, then that would still apply and you would expect to still receive those payments from the employer. In terms of charging orders, however, and this is just a final point on this, whilst they are, you would have noted that earlier I said secured credit aren't qualifying debts. That really is things like mortgages and hire purchase agreements. It doesn't include charging orders, which, as you'll all be aware, are secured, security for your judgment or your debt. Those cannot be enforced during a breathing space. So if you were going to apply for an order for sale, you wouldn't be able to. You'd need to put that on hold until the end of the breathing space. That's all well and good, Nick, but what do we do if we're notified of a breathing space? Well, I'm going to talk you through the slide carefully on this one, and then add a few extra bits, because this one's actually very, obviously one of the most important ones, one of the most important points, which is if you're notified of a breathing space, without delay, the first thing you need to do is, first of all, identify whether the debt that you have is covered by the moratorium. Is it covered by the breathing space? As I've already said, I anticipate the answer is probably yes, but it might be that it isn't. The second is to note the type of breathing space that has been applied for. Is it a standard breathing space or a mental health breathing space? Because if it's a standard breathing space, obviously you know that you can put in a 60-day timeline before you can start pursuing them again. If it's a mental health breathing space, you're going to need to liaise with the debt advisor or the local authority or whoever notified you to understand a little more about how long the treatment is anticipated to last. And if it does go on, as I said earlier, if the treatment does go on for a period of time, to keep in touch with them to understand, when's it likely to end. The next point is to check that the notification came from an authorised debt advice provider. As I said earlier, individuals just can't put their hand up and say, I've decided to take a breathing space. This is all getting a bit much for me, because that would lead to abuse of the system. There are safeguards in place, and that is that it has to be approved by a local authority or a financial conduct authority approved debt counsellor or debt advice company. That's the reason that I think these are going to be slightly harder to obtain than I suppose the concern may be. I can imagine a lot of people are concerned that everyone who has any debt is going to suddenly say, I need a breathing space. I don't think they're going to be as easy to get as all that. And I think they obviously serve a very specific purpose, which is to try to enable people to take debt advice and advice on how they're going to improve their position because 60 days isn't very long. It's so that you can come back to your creditors with a sensible proposal. That's my personal view. The next point is to stop chasing the relevant debt. and inform your agents to stop. That's an important point, because obviously if your agents don't know that there's been a moratorium notified, they could carry on pursuing the debtor. And if they carry on pursuing the debtor, then you'd be in breach of your obligations as a creditor. But also you'd obviously incur costs or liability for costs, both of your agents, but also costs that the debtor may incur dealing with the agents that are still pursuing them. The next is obviously, I've already said this one briefly, but to notify the court if there are proceedings in existence. This could be a court claim, or it could be bankruptcy petition, any of those. If you have any of those in place at the time and the process is ongoing, the court should be told. Certain parts of a court claim can be allowed to continue. So compliance with certain orders can continue during a breathing space, but the court, once informed, may give an order one way or another. But either way, they're not going to progress it to a hearing, for example, during a breathing space. The next point is to notify the debt advisor of any additional debts that the debtor may owe to you. So whilst you may have a headline debt, there may be additional debts. For example, school fees are accruing constantly, and at the end of one term, obviously you'll raise an invoice for the next term, and if that falls over a breathing space, that should be notified to the debt advice company as well. In terms of the next point, which is and really another one of the main points, which is to challenge and or diarise the end of the breathing space. So this is just so you know when you can recommence action.
Nick, just to step in a moment, we've had some very understandable and sensible queries about how far does the breathing space extend? So does it mean you can't serve notice to exclude a pupil for non-payment? No, it doesn't, because that is a contractual right to do. It's not a debt recovery action. So that was one piece. Mm-hmm. And the other question that was asked was, do we have an obligation to continue to perform our other duties? If we're not meant to contact a debtor, how do we fulfill our contractual duties? And again, the answer is, if you are considering court action against a debtor, and in that context, they are still a pupil at the school, or you still have obligations towards them, then the unrelated matters should continue in that way. Sorry to interrupt. I know you're about to go on to the next slide, which is whether breathing spaces can be challenged.
Yes, absolutely. But thank you, Tabs. That is, and for the question askers, because it's those are very valid points, and it has to be highlighted that when I'm saying don't contact the debtor, it's don't contact the debtor about the debt, about the matter in issue that they have a moratorium in respect of. And the final point on this slide is to stop interest and charges accruing, or put in place means to record the amount of interest and charges that are accruing, so that those can later be subtracted from the debt. I've already said that an individual can't notify you of a debt. It has to be a debt advisor. If you are in any doubt as to whether this is valid, you've been notified of something but you just don't know, and you're not sure if you trust the debt advice provider, check with the insolvency service. The debt advice provider, when they notify you, should have provided details of the insolvency service. And I don't yet know what this will look like, but I'd anticipate it would be a code or a link through to the insolvency services page for that particular debtor. And in that situation, you can register with the insolvency service as a creditor of that person and give them details that you would like to be contacted on in future by the insolvency service about this, for updates and things like that. The important thing there as well, another important thing, so many important things, make sure that you have arrangements in place, particularly when people are on holiday or you're in the school holidays. make sure there are arrangements in place, if possible, for notifications to be picked up, because obviously, a school holiday, I know that most finance teams have the joy of being in over a school holiday, but in the instance when lots of people are away, it's just easy for these things to slip through the cracks, and obviously you don't want that to happen. If we could move on to the next slide, please, which is about, can you challenge a breathing space? And the answer is yes. You can challenge within 20 days of the breathing space starting. It's probably only worth challenging if you, in fairness, feel that you've been unfairly prejudiced by the breathing space, or because you know or have strong reason to believe that a debtor does actually have means to pay its debts, not only to you, but perhaps to other people as well, because obviously this is a holistic issue a lot of the time. And how do you make this application? How do you challenge a moratorium? Well, you make a written application to the debt advisor who approved it in the first instance, most likely being the party that wrote to you to notify of the breathing space. And you write to them with evidence, and then that debt advisor will decide whether or not there is it's a valid challenge or not. In terms of if it is a valid challenge, they can cancel the breathing space. And if we move on to the next slide, the debt advisor, if he agrees with you, he's under a duty to cancel the breathing space. And being authorized by the Financial Conduct Authority, you would hope that they would obviously do it with the creditor's best interests at heart, as well as those of the debtor. And they will do so unless it's unfair or unreasonable to do so, particularly if it's going to be unfair or unreasonable to a debtor who understands that they are taking steps to deal with a debt period, with their debt over this breathing space period. If you don't like the decision of the debt advisor, you can challenge that further. You can challenge that to the court. Again, you can make an application within 50 days. It has to be basically on exactly the same terms as the application that you made to the debt advisor. Obviously, you can only make it after the debt advisor has made his decision, which you don't agree with, and you have to make that application within 50 days of the start of the breathing space. Now, obviously, given a breathing space, if it's a standard breathing space, is only 60 days. We don't know how long the debt advisor is going to have taken to make their decision. It could be that it's actually, in terms of standard breathing spaces, not particularly worthwhile challenging to court a breathing space. However, this is probably going to be very helpful, or more helpful, in a mental health breathing space situation, or where the debt advisor has been able to turn a decision around very quickly, and you think that there are actually some ancillary reasons why the breathing space was applied for and put in place in the first instance. And finally, you may all be thinking, well, that's all very good, Nick. You've told me what I can and can't do, but so what? What are the consequences of me deciding to carry on? What are the consequences of me breaching the regulations and my obligations under them as a creditor? I think the most important one is that your enforcement action, whatever you've done, will be null and void. So if you do take further steps to enforce, or you take payment through HCEO, for example, who you've instructed as a bailiff to attend the property, and they take payment, or you keep pursuing and you get payment that way. If you get payment, then that's going to have to be, or that's going to be subject to being returned to the debtor, because you shouldn't have taken that action. And the costs of your team, your agents, and also the debtor's costs in dealing with any action that you've taken during that period of time are also likely to have to be paid by you. How those will be determined in terms of the debtor's costs is uncertain, but they may also claim, they could claim harassment if you keep pursuing them and that sort of thing when they've got a legally founded breathing space in place. And of course, they may raise complaints, taking up not only your time, if they just raise complaints through your own complaints process, but they may raise complaints with regulators, which can also obviously cause headaches that none of us really want to have to deal with. And finally, is my final slide, which is about other changes. Now, this is obviously the big one, as I see it, because it's the change that I think has the most scope for affecting you as schools who are pursuing school fees. But there are inevitably going to be other things that happen. There is no other legislation on the books that I think is going to have a significant impact on you. But it won't surprise you, Tabs has already mentioned it, court delays and backlog. This is unlikely to improve anytime soon. Tabs has already inferred that, but I think it's going to get significantly worse. Insolvencies, which use the same courts and the same personnel, haven't been happening over the last year and a half because legislation has put in place that companies will make it it's a lot harder to make a company insolvent than it previously was. And that's coming to an end. That large moratorium is coming to an end. And I think we're going to see a significant upturn in action in that sense, but also individuals making themselves either bankrupt or companies making themselves, winding themselves up. Which will...
Okay, that's great, thank you. Can we move on to the sort of any questions? Because I'm conscious.
Yes, I was going to do that. That was very much the next thing I was doing. Sorry.
Great questions. So if I take those, the first one was, are we able to notify another school that a family have unpaid fees? Our terms and conditions allow for it, but are due a refresh. And the answer is, if it is in your terms and conditions, then you can do so. You will need to think that through about whether it is appropriate to do. But I think the legal justification for doing so and the need to pursue unpaid fees will get you there, subject to your data controller or person responsible for data protection being comfortable with you doing so. Has asked a really interesting question about whether we should be signposting parents with outstanding debt to the debt respite scheme. Now, we already have an obligation to tell debtors where they should go to get some advice. In every letter of claim that we send on your behalf, there is a list of debt advisors, places they can go to get free advice to help. Those advisors should be telling them about the debt respite scheme. We will give some thought to the extent to which it should be expressly signposted in that way, and we'll let you know. One of the things I would say, though, in relation to all of this is I would express real caution about giving somebody 60 days if they ask for it without it being asked for on an official basis under the debt respite scheme. Because if they are eligible for the scheme, they could then go contact a debt advisor and you'd have to give another 60 days from doing it. So do just think about the interplay between the two. Mm. And the last question we had is in terms of fees in lieu, and I'm really glad to hear that somebody has asked this because the question was, is Mountain Oldham still good law and the recovery of fees in lieu of notice? And the answer is no, it isn't. And the situation is thankfully much clearer now. And that's following the Supreme Court judgment of Parking Eye. And in the Supreme Court judgment, they considered whether fees or contractual fees which don't directly relate to the loss suffered should be recoverable, and alternatively whether it would be an unenforceable penalty in those circumstances. And the Supreme Court introduced the concept of a legitimate interest. And in that scenario, it was a private parking agent who was charging £80 for somebody who was a few minutes over their allotted car parking time. And the court was satisfied that it was in the legitimate interest to deal with that in the deterrent effect. So legitimate interest takes into account social and other factors, as well as the purely financial ones. I'll make sure that when we do the follow-up to this, which is going to include the slides and the video recording, that we also have the article that we wrote about complaints procedures and also the citation for the parking eye case, so that if you don't have it on your books, you have it there to be able to draw to debtors' attention as and when appropriate. I can see that there's some more questions that have come in. Let me just take a look at those, unless Nick, you're ready to pick any up.
Well, there was one that I think is probably more for you than me anyway, which is will we need to amend the terms of our school fees recovery scheme to accommodate changes highlighted by me?
So no, it won't need to be updated. So for those of you who don't know, we act for about 150 schools on the school fees recovery scheme, which is a discounted debt recovery option. We also act for about another 50 schools on a standard retainer basis for debt and related topics in that way. And the scheme now covers debt recovery and the service of statutory demands. The debt respite scheme is another procedural hurdle we have to deal with, but it doesn't change what we need to do. So no, we won't need to do that. There are some other questions which I will try to get to people individually to pick those up, given where we are with time. I think that's the best. They're all got named individuals, so I'll be able to pick those up. And if appropriate, I'll add those to the follow-up. Thank you. Thank you all for joining us.